okayfm 101.7.
Honorable Alhaji Inusah Fuseini, where teacher ni tetewo na obia sabre your friend teacher Inusah na so affable person. Now a former MP for Tamale Central, former minister for roads and highways. Honorable Memochi. Boko teacher Inusah. Na unam kwa so kwa hini. Wow. But we miss you in Parliament, oh.
Oh yeah, that's okay.
Now say me dawa me so da na we a flag bearer.
Hey no.
Na Alhaji mama unchen a we emranimu ni lawyer, astute one. The akoso na Supreme Court the ruling aba per the appeal marking year de call you know it will say
Oh yeah. Because when see I see how the Supreme Court is taken to do an indirect means what you cannot do correctly.
You be law adin my kakra bibi wachi
Me tell the work already so you know
okay but you me too
so I did me can say I was quite taken aback because what the Supreme Court Supreme Court now you know is trying to do indirectly what it cannot do directly.
Uche say
Supreme Court any to me to interfere in the internal workings of Parliament. Supreme Court susu a creature of the Constitution into a one jurisdiction. Now the Supreme Court jurisdiction is not at large. That is not the jurisdiction of the Supreme Court.
It matters in respect of say you will be declare seat vacant no. Speaker no so does it lie in his power?
Yes. Article 97 vests that power in the Speaker. So it doesn't lie with the Supreme Court. In fact, the nearest a court can declare a seat vacant is in Article 99, where there's a challenge to the election of a member of Parliament. Then the High Court, if it comes to the conclusion that that member of Parliament was not validly elected, can declare that seat vacant.
Yeah, 99 A.
I'm just telling you, say me catch you say the nearest jurisdiction of the court to declaring a seat vacant is in Article 99.
But whereby Obiaba seeking for interpretation.
Interpretation is a different thing than declaring a seat vacant. Declaring a seat vacant is within the preserve of the Speaker of Parliament.
Article
97.
Article 97, Mami Mihe. Article 97G, and our kana. I'll say, my preamble. A member of Parliament shall vacate his seat in Parliament. G. If he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as independent, or he was elected a member of Parliament as an independent candidate and joins another party. Now, Mami Musao, they took a legal step. Now, Muhammad Moka or the uttering pattern rule. 18 can speak no one tier man masem. 2.
The Supreme Court is totally wrong.
Me pa me bo. Me dey make case.
No, you don't need to go there.
Okay.
I'm telling you that the Supreme Court is totally wrong.
Why?
In Article 97.
Okay.
The same Article 97, where the drafters and framers of the Constitution intended that before the declaration of a seat vacant, the Speaker must listen to the other party. the framers have provided it in Article 97. Article 97, where the framers were of the view that before the declaration of a seat vacant, the speaker must listen to the other party. They provided it in that Article 97. And you know the case of Ajua Safu. One of the grounds that Parliament can declare a seat vacant, the Speaker can declare a seat vacant, is when a member of Parliament absents him or herself for 15 sitting days without the permission of the Speaker and without a reasonable explanation to a committee of Parliament. Ultimate cancer provisional extra amount for is under Article 97.
Article 97 G.
No, not G. Article 97, I think C or so, where the
okay, Mamen can Article 97 1C. Was C. A member of Parliament shall vacate his seat in Parliament, C, if he is absent without the permission in writing of the Speaker, and is unable to offer reasonable explanation to Parliamentary Committee on Privileges for 15 seconds of a meeting of Parliament during any period that Parliament has been summoned to meet and continue to meet, or if he is expelled from Parliament after having
no.
Okay,
I just want that one. The person who said the same Article 97 provides for the Speaker to listen to the other party, the rules of natural justice to apply.
Sure.
In that provision, but doesn't apply for others. For instance, where a person has resigned by his own writing as a member of Parliament, does it provide that the Speaker must listen to the other party?
No.
Where a person has died, does it provide that the Speaker must wake that dead person up?
No.
So what are they talking about?
Papa, Mami Musadio, party I want belong to no.
So the Speaker is wrong, totally wrong.
Papa, Mami Musadio, party I want free moon. Where expression of intent. Senior Parliament, where I still remain with my party. Name of the next Parliament, I will not remain with them.
So there are 2 reasons or 3 reasons why that intent is consequential. 3 reasons. Number one, the Speaker Michael Quay in 2020 November ruled that Andrew Esiama, now on MP on the ticket of MPP in Parliament. Now, you have pre-election 2020, offering Parliament, offering the party, echo contested as an independent member of Parliament. The party petitioning the Speaker, invoking constitutional provisions and expelling Andrew Esiama from the party. Every say on the party no view. He had lost that position as a member of Parliament because member of Parliament is an office of the party. The which party so that's why that member of Parliament is sponsored by the party. So who need party no view? You are taking an action or you are engaged in activities that is inconsistent with the party's philosophy and ideology. You see, won't mean continue to occupy that office of a party when you are doing things contrary to the party. And immediately you lose your membership of the party, you have to lose your membership of Parliament.
Papa, yeah,
that's number one.
Okay.
Number two, Supreme Court, Makoke Ma ruling no 4 years ni Obiara and challenge. Number three, Article 97(2), 97(2) say, not notwithstanding the provisions in Article 97 1G and H, if there is a coalition in Parliament and a member of Parliament from another party sits with another party for the purposes of conducting business, and that is allowed and sanctioned by the party, that person will not be said to have crossed carpet. So, when Andrew Esiama came to Parliament as an independent member of Parliament, he chose to sit with the MPP and Anyasa.
Sanity.
Did they declare his seat vacant?
No.
But that was a future intention that actualized in Parliament. Not so.
Papa,
he chose.
In law.
Number
what?
3, Miba.
Okay.
Number 3, when a speaker rules under Article 97, 1G and H, that ruling is based on the understanding by the speaker of the implications of Article 97, 1G and H. But that ruling is subject to interpretation in court. So if you go to court for an interpretation, that is not an interference in the decision of Parliament. That is seeking a clear, authoritative interpretation of that provision. Because every day we are interpreting the Constitution to guide our activities. But it is only the Supreme Court that can provide an authoritative interpretation. So when you go to court for an interpretation, it doesn't operate retroactively to affect everything. So if you interpret the Constitution, this is the position of the Constitution. It will, and that the Makokwe was wrong in sacking Adeyi in this Esiama from Parliament. That will not operate to bring back Andrew Esiama to Parliament, because that Parliament is gone. So the fact that the MPP went to court for interpretation is not mutually inconsistent.
Honorable, my question common maybe. One. Okay.
Or static cases. You are a respected member of the bar. Don't be mentioning cases by heart. Because what is the Zenoto case? What is the Zenoto case? What was the locus depedendi of the Zenoto case? The Zenoto case sought to answer when is a person said to have filed for Parliament, to be eligible to file for Parliament. That was the question the Zenoto case was answering. It was not answering whether or not the Supreme Court can stay the hand of Parliament. It was not answering that question. So don't be mentioning cases and citing cases for what? Because you confuse the public and you fail to do justice to the matter. Hello? Hello?
I want to meet you.
And you remember Minimuka interview some in the Asen North case. You remember?
Yeah, I'm a cousin of Jachi Kwesi.
And I told you that the Supreme Court was processing a jurisprudence of convenience. Okay.
Okay.
Well, okay. And people insulted me proper. Okay. Okay.
And the same year, no crabby or alcohol canteen, the other down, baby.
You see, when I said that as a lawyer, I saw convenience, jurisprudence of convenience in the decisions of the Supreme Court. Me say in that question, Supreme Court say that question should not go to Parliament. Okay. Now omunya nipa ana. No more here representation. No more here representation. I don't think the Supreme Court will say that the question more on court Parliament until the determination of the case. The same Supreme Court too. Okay, Centrofi Apafo, le lobby and Lipe, who can you 4 years. 4 years. A suit is lying at the Supreme Court. 4 years. Okay. Now, enclave no. Omo here representation.
I see. Now, honorable.
Then the Supreme Court is not saying that by reason of the fact that some people will lose representatives in Parliament, the people should go. This is clearly jurisprudence of convenience.
And no, yeah, one of the grounds. Now, I don't know, Mami Musadio. Speaker, did he take the pains? So, Fred, the affected members of Parliament, say, no cross, one expressing this intent or legal step. 2, more party, and now more film.
Oh, Minia. Minia, my dear country, say, constitution under Article 97. Can you demonstrated to you, sir, where the framers of the Constitution intended that those people be called and asked, it provides it.
Papa, the Busa San say, every crowd of friend on because and Pacha wo, Minquajina baby, and to me, Ben, so as you ask the question, Mr. Wendras is out. Not to me, Ben, did the Speaker have to call the people? Okay.
Because in
based on rules of natural justice.
Article 97(1)(c), if the Speaker declares a seat of a sitting member of Parliament vacant on the basis of absence from Parliament, with a reference to the Committee on Privileges, that decision will be unconstitutional.
I see. Now, Baba Mami, we are dealing per the Supreme Court ruling. Matisa and Ransono, NDC, Kokosuno, I meeting said they will not be binded by the ruling of the Supreme Court. Now, and no, they didn't say, and it's a directly speaker. Speaker, I'm fair, would that?
How can the Supreme Court direct the Speaker to allow that? How can the Supreme Court do that? You have arrogated to themselves powers they don't have.
Would that not be
powers infinitum? Ad infinitum. The Supreme Court doesn't have it.
They don't
have that power. The Speaker.
Say, man, fine, yes, means cited the Speaker for contempt.
The Supreme Court should even be cited for contempt of Parliament. Parliament has taken a decision, and then you sit down as Supreme Court to superimpose yourself on Parliament and direct Parliament how to perform its functions. What to be that?
So there will be legal chaos.
They have provided the legal chaos. They should have concerned themselves. People should have concerned themselves with interpreting the Constitution. That's their jurisdiction.
I see.
That's their jurisdiction.
Eddie Ochinano says, Speaker and find yet Juma.
Speaker and find yet Juma.
Wow.
Because that will be subordinating Parliament to the Supreme Court.
Nana,
they're independent arms of government, for God's sake.
But
that is what democracy is all about.
But Supreme Court, you know, so one more, they are there to do the checks and balances.
But Parliament too is there to do the checks and balances.
Wow.
And the people are there too to do the checks and balances. The people decided to establish a Supreme Court and vest it with specific jurisdiction. Example, the Supreme Court has no speculative jurisdiction. So when the Supreme Court says that government business will run into chaos, they're invoking a jurisdiction they don't have.
Okay.
It's speculative.
Yeah, okay. Alhaji Mami na wase no pe wati.
And that's it.
Bye bye. Okay, 101.7 so na Honorable Alhaji Inusah Fuseini, former MP, Family Central, former Minister for Roads and Highways, and astute lawyer, and I came come now.
OKFM 101.7.